Time for us to check in with CJAD 800 legal contributor Chris Dimakos. Chris, interesting topic today. We're not talking about the workplace today. Well, sort of not. It's a story that you found about a dog sitter attacked and bitten, that was her job, by the dog that she had been paid to watch. And she sustained pretty severe injuries, apparently, and ended up suing, but the court refused her claim. So let's look at that case specifically and then generally how it applies across the board. So what happened here and why did the court simply say no?
Yeah, so we have a woman who puts ads in social media that she walks dogs, she's a dog sitter, takes care of your dog when you can't be there. And she ends up signing a contract with one of the dog owners who has her watch the dog during the day at his home while he's at work. And it was snowing out, and the dog was supposed to wear these little boots because he had an infection or something. So she tries to get the boots onto this dog, which appears to be one of these dogs with a huge jaw that would be otherwise muzzled. But that being said, as she's trying to put these boots on this dog, the dog gets extremely upset and starts biting her arm, shaking her arm, bites her in the stomach, bites her a couple of times, and she had to go to the hospital. And she suffered some serious injuries, and she sues. She sues the dog owner in court, and then they went through the whole gamut, and then basically the court ruled and said, look, when you are advertising yourself as a dog sitter or a dog walker, you are accepting an inherent risk that the dog might do something, and you almost become part of that ownership circle of this dog. They call it dog ownership. You're not the actual owner of the dog, but because you are watching the dog, sitting the dog, you basically accept risks that come with that job. So this claim was denied. And again, there are a lot of different factors, but what people should take from this case is that if you are a vet, if you are a dog walker, or even if you're a family friend that wants to, watch people's dogs and have them over, it's not an automatic that if the dog does something out of character that you're automatically going to be compensated. So there are risks involved with watching dogs and walking dogs. And if you're accepting those risks, you're limiting what you can claim afterwards if things go wrong.
Okay. It seems a bit extreme to deny her claim. Suing for $1 million also seems a bit extreme, to be fair. Was there any award here? Can you expect that you would get something for something like this?
Right. So the courts, that's a great question. The court said, well, when would someone be able to claim? If let's just say that dog sitter asked questions about the dog and said, hey, is the dog aggressive? Has the dog ever bitten any? And the owner of the dog says no to everything. But the truth is that the dog, can be or has been aggressive. Well, then the owner of the dog would be liable for that. You can't basically con someone into accepting a job when they think there's little to no risk, and then there is a big risk. So in cases where the owners are not completely transparent with you about the dog and the behavior, you would be entitled to claim. But that was not the case here. The sitter, in this case, didn't ask any of those questions. She didn't care to ask those questions. She advertised herself as someone who was great with all kinds of dogs, and that's why that happened. But important question that you asked, it's if the dog owners are not transparent. If you bring your dog to the vet and you don't tell the vet that the dog sometimes can be, aggressive, well, then the vet might say, hey, I'm accepting risk here, but you got to tell me if your dog has acted out in the past. I need to know that going in, because if I don't, I might end up getting bitten for no reason.
So wait a sec. To that end, is there no responsibility here for the owner of the dog at all?
There is a responsibility when it comes to people that are outside of that circle, that, the vets, the doctors, the sitters. If you're walking in the park and your dog that bites somebody else, then of course you're absolutely responsible as a dog owner. That person, didn't undertake for money to watch your dog. They're just somebody who's enjoying the park on that day. So you are responsible for all of the damages that your dog causes. But the rules change when someone is getting paid to watch your dog, or somebody becomes part of that dog ownership. You might not be the actual owner, but you are acting like the owner. You're sitting to that dog. You're walking that dog. So you become a quasi-type owner of that dog.
So obviously this sets a precedent in some cases. There are plenty of people who do this, offer to walk your dog. And now in a case like this, If you're one of those people, what are you supposed to do? Clear it with the owner beforehand? Anything I should know about your animal? I mean, how do you protect yourself as that person?
Absolutely. Exactly. So what you should, if that's what you do, and it's great that you're doing that, if that's the type of work you're going to be doing, you want to ask questions about the dog and about its behavior and about the risks. The key here is risk. What are you accepting as a risk? And if you accept the risk, either because you didn't bother to ask, or because you heard what the answers were and you were fine with it nonetheless,
okay,
well, then you can't sue. It's when you didn't accept the risk, when you weren't aware of them,
got it,
either because someone didn't tell them to you or they lied to you, that's when you can claim damages.
Okay, we have a couple of minutes. I want to get to the second story. I find this quite interesting as well, the one that you have here. A teacher deciding, you know what, I have a vacation coming up, and decides he's going to add, or she's going to add 3 sick days prior to spring break when they would be off to extend that vacation. And that teacher, for doing that, gets suspended. What happened here?
Right. So the teacher had a spring break trip planned to take a flight to Japan. And they said, you know what, I can extend this. I'm going to take my 3 paid sick days, 1, 2, 3, immediately prior to spring break starting. And they did that. So they basically went online and filled out the paperwork, the questionnaire. I'm sick these 3 days. I'm not coming to school. And then after that, on social media, pictures, airports, all these things, trying new foods. And then people who worked with this teacher said, well, they got extra time paid for because they said they were sick when they weren't. So the administration basically came down on that teacher and said, look, you cannot use sick days to extend a vacation. That's not how it works. That's considered time theft. So the teacher was suspended for 2 weeks. And there's a whole bunch of things that went wrong there. But the key here is, if you're going to take a sick day and it's paid, because we do have paid sick days here in Quebec, not many, but we do. If you're going to do so and you're not sick, make sure you're not on social media advertising that you're either on Crescent Street or at the Grand Prix or whatever it is you're doing. You might want to be a little more discreet about what you're doing on your sick day.
Now, I just have a question. I mean, you bank sick days sometimes too, right? If you have them and you want to use them, why can't you use them wherever you want to? Or is the idea here you have to prove you were sick in order to use a sick day at that time?
Yeah, so another great question. So sick days are not considered extra vacation days. Like they're considered only there if you need them. So it's not as if you have them, you have to use them. And if you don't use them, you accumulate them. They're there when you need them. And if you don't need them, then they were never there to begin with. And in Quebec, the law has evolved where an employer can't ask you for a sick note or doctor's note unless you are gone for 3 consecutive days. So if you are sick and you call in sick for 1 day or 2 days, the employer cannot say, bring me a doctor's note. They don't want people going to the doctor when they're sick. Yeah. They don't want them to clog up the system. But once you surpass that 3-day threshold, that's when they can start saying, okay, you've been gone for 3 straight days. Can you bring us a doctor's note here?
So the case you're making here is if this teacher had simply taken 2 days, this wouldn't even be a story.
Well, maybe yes and no. I mean, the fact that they did take the sick days and they advertised that they were traveling and having fun.
Either way would have been a problem.
That's the problem.
Got it. There, too. Okay, heads up, teachers. Chris Dimakos, our CJAD 800 legal contributor. Thank you, Chris.
Thanks, Aaron.
iHeartRadio is throwing it back.
2010s, the decade.
To the days of huge hits and unforgettable anthems. A non-stop stream of the biggest and best.
Drake, Rihanna, Beyonce, Katy, Gaga, The Weeknd,
and more. All your decade-defining favorites, all in one place.
Hi, it's Katy Perry.
Hey, it's Bruno Mars.
This is Kesha.
Find 2010's The Decade on the free iHeartRadio app. Preset the station so it's always one tap away.